Test. Test. Test mic 1. Test mic 1. Test mic 2. Test mic 2. Test mic 3. Test mic 3. Chief's mic. Test mic 3. Test mic 4. Test mic 4. Test. Test. Test mic 5. Test mic 5. Test. Test. Test mic 6, podium mic, test mic 6. Test. Test mic 1, test mic 1. Test mic 2, test mic 2. Test mic 3, test mic 3. Chief's mic, test mic 3. Test mic 4, test mic 4. Test, test. Test mic 5, test mic 5. Test, test. Test mic 6, test mic 6. Test, test.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
Oh, Danny boy, the pipes are calling from glen to glen and down the mountainside. The summer's gone and all the flowers are dying. 'Tis you must go and I must bide. But come ye back when summer's in the meadow, or when the valley's hushed and white with snow. 'Tis I'll be there in sunlight or in shadow. Oh, Danny boy, I love you so.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
the pipes are calling from glen to glen and down the mountainside. The summer's gone and all the flowers are dying. 'Tis you must go and I must bide. But come ye back when summer's in the meadow, or when the valley's hushed and white with snow. 'Tis I'll be there in sunlight or in shadow. Oh, Danny boy, I love you so.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
the coming of the Lord. He is trampling out the vintage where the grapes of wrath are stored. He has loosed his faithful lightning of his terrible swift sword. His truth is marching on. Glory, glory, hallelujah. Glory, glory, hallelujah. His truth is marching Hallelujah, glory, glory, hallelujah, glory, hallelujah. His truth is marching on.
This next song is written about losing someone that you love. Step outside with me and look for a star as we play Dust to Stardust.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
session. You may be seated. Thank you. Good morning. The first case set for argument this morning is appeal number 31143, State of South Dakota versus David Sangru. Blue Bowen is arguing on behalf of the defendant, Mr. Sangru, and Aaron Hankey is arguing on behalf of the State of South Dakota. Each side will have 15 minutes for your initial argument, and then Mr. Balloon, you'll have a 5-minute rebuttal. You can proceed at this time, Mr. Balloon.
Good morning. My name is Bo Bluen, attorney with the South Dakota Office of Indigent Legal Services. I represent the defendant and appellant, David Sangru Jr., in this matter. This case turns on a critical point. The state's removal of a Native American prospective juror based on reasons marked by misstatements in the record, shifting explanations, and speculation cannot withstand scrutiny under Batson's Step 3 analysis and compels a finding of clear error. Mr. Sangru respectfully asks this court to vacate his conviction and order a new trial, or in the alternative, to remand this case for further proceedings under Batson. I'll focus the majority of my time this morning addressing the first issue, the denial of the Batson challenge, and I'll address issue 2 if there's time remaining, or of course if the court has any questions with regard to that issue. Now, the Supreme Court's landmark decision in Batson v. Kentucky recognized that even more subtle forms of discrimination undermine the integrity of the justice system. And it imposed a clear duty on courts to ensure that discrimination in peremptory challenges, that they are not used as a tool of exclusion. And the Batson line of cases reinforced 2 important points here. The first is that the peremptory challenge process is uniquely susceptible to being used as a vehicle for racial exclusion. And second, racial discrimination does not require racial animus. A strike made even on the mistaken belief that a juror will improperly favor a defendant because of their shared race is itself a form of racial discrimination under Batson. And the court instructed that the Constitution forbids the striking of even a single juror on account of race. Now, once a Batson challenge is raised and the defendant makes a prima facie case, enough facts giving rise to an inference of racial discrimination in Step 1, and the court...
we may be beyond that in this case.
Okay.
Maybe. But whether we are or we aren't, the question, Mr. Balloon, that I have is, what is there other than the strike itself and what we know about the juror's status as a Native American? What is there that would suggest that this was a strike founded upon or based upon his race?
Yeah, well, I think it starts with the fact Mr. Sangru Jr. is a Native American, a cognizable racial group. The state used a peremptory strike on one of 2 Native American prospective jurors.
As I understand it, the defense also used a strike, peremptory strike against a Native American as well, or at least that was said and no one corrected that. But in any event, but that really leaves us, and I interrupt you, I'm gonna let you finish, I'm awfully sorry, but that just leaves us with the fact of the strike itself, and the race. And I know these things aren't spelled out, and that's part of the sort of the work of the court to figure this out, but it seems like we just have a kind of an ipso facto argument here. Because this person was struck because they're Native American, we have a Batson challenge.
Well, and I think that's the starting point in the prima facie case, is that you have those 2 facts that have been recognized to satisfy the prima facie case. The Batson court noted that once those 2 requirements are met, that the defendant can rely upon the fact that the peremptory challenge process allows those who are of a mind to discriminate. And so it's an acknowledgement of the susceptibility that this has been and is a widespread issue and a reoccurring problem. Beyond that, we have Juror 78, who was responsive, who was actively volunteering answers, confirmed that he could be fair and impartial to both sides, and
But of course, it wasn't a challenge for cause. And really, his qualifications as a good juror or not a good juror can't really figure into any step. It certainly wouldn't figure into the final analysis, would it?
well, I think that, the court is instructed to take in mind all of the relevant facts. You look at the total picture. And so when you do have a juror who is confirming his impartiality, that's a factor that the court takes in when they're assessing the credibility of the reasons proffered by the state.
And that's exactly what the court did. The court made a finding that the state had provided a race-neutral explanation, and we typically apply a very deferential review to that. What about this case suggests that that deferential review should result in us saying the circuit court got it wrong?
Yes. So it is a credibility assessment, and this court has indicated that it provides the court deference in its credibility assessment. But credibility is not simply based on the prosecutor's demeanor. This court has stated that that's one factor that can be looked at, but also the state's justifications, and are they plausible? Do they hold up? Are they inconsistent? Are there indicators of pretext that indicate that these were not the real reasons, but they were actually pretext for racial exclusion?
But didn't the circuit court take all that into account? All the same arguments were made before the circuit court.
So the circuit court did make a finding that the state's reasons were not pretext based on racial exclusion, and I acknowledge that this court has previously stated in Guthmiller, for example, that a trial court implicitly conducts the required analysis when it accepts or rejects the state's reasons. But here, there was evidence and indicators in the record that the trial court made an ultimate determination that was based on an incomplete recollection of the record. And one, I guess, example of that would be with regard to the court's oral findings on the record with regard to the state's lack of any follow-up questions to the juror with regard to his prior interaction with law enforcement. The court indicated there wasn't even a second question asked. But when you look at the record, there were some follow-up questions asked, one of which was, anything about this situation that you would hold against the state in its case. The juror unequivocally answered no. The juror clarified that this was 20 years ago, that it was in a different county. None of the officers involved in that case were connected to this case. And the prosecutor even remarked that he would have only been 10 years old at the time, almost to emphasize how long ago this was. And so when the trial court said there was no second question asked, that indicates that it did not have the complete picture, and those were highly relevant factors in the Step 3 analysis. The other indication that the analysis was incomplete was inherent in one of the stated reasons accepted by the court for the strike, and that was the possibility of criminal history is what the court found on the record. Now, inclusion of the word possibility, I think, demonstrates that the ultimate determination was based on some speculation. We had the criminal history sheet that belonged to the state, was provided to the defense, showed no criminal history at all for this.
But in this case, so when he answered that question, the juror 78, when he answered that question, he said that he was handcuffed, he was mistreated by the police and so on. Could it be that the state just made a tactical decision not to really want to ask any more questions about that incident? They're not really required to. They don't want to. What if they don't want to poison the jury pool, for example?
Well, that could be, but I think when you look at the actual back and forth discussion, you do see that the state did ask some questions, and you can see the prosecutor's sort of inconsequential treatment of the jurors' comments. And I think it certainly bears on the credibility issue that the state didn't even bring that up initially. They referred to it as comments on criminal history.
But since he himself said that he was handcuffed during that incident, I mean, is it that far of a stretch for the state to just say that, well, looks like he might have some criminal history, we're going to use a preemptory challenge without any racial animus whatsoever or motivation?
Well, I think
Wouldn't they be allowed to do that?
I think under a different set of facts, that could certainly be a possibility, but I think the record here shows that the comments themselves were described as criminal history. The prosecutor admitted to having a difficult time understanding what was said. I think that the characterization, the glaring mischaracterization of this as criminal history could also be interpreted.
What if the state had just accurately said, our problem with him is that he's had a negative interaction with law enforcement in the past?
If the reasons had been consistent throughout, of course that's applicable to the step 3 analysis, and that could change how the court looks at this. But it should also be kept in mind that the prosecutor described this as a known criminal history. He had even looked this up beforehand. But then when asked what this criminal history was, the prosecutor couldn't even provide a vague description.
Well, there was a questionnaire, there was a juror questionnaire, and the court ultimately looked at the questionnaire as well. It said, where juror 78 had said that he had a criminal history that was more than just speeding violations or traffic tickets or something like that. So he indicated he had something that was more serious than whatever, traffic violations or something like that. So there just seemed to be some support for that.
Yeah, and I think you look at the criminal history sheet that showed no criminal history whatsoever, and so that raises the question, what is this? Is it a class 2 misdemeanor from 25 years ago? And the prosecutor didn't know.
Presuming that there's some waffling, it seems to me that you're indicating there was some waffling here, shifting explanations. Ultimately, under step 3, it's up to the trial court to determine credibility. And the trial court did determine credibility. Where did the trial court go wrong then? I mean, under our deferential standard of review, what do we look at?
Well, I think one of the things that I previously brought up was the lack of follow-through questioning, the incomplete recollection of the record. You look at the
That's stepping back. That's stepping back. I mean, the voir dire is done. We're now at the preemptory stage, and the judge has received these explanations and makes a credibility finding under step 3 that is not a pretext. Where did the judge go wrong for us to overrule her?
Well, I think by reading the record, you can see that there was a lack of clarity from the court on the state's reasons, having to ask the prosecutor to restate its reasons because of all the variation and inconsistencies. And without reading back the record, I think it would have been difficult, if not impossible, to really appreciate the sequencing and the variation of the statements. And under Batson, these were really important factors to review to really assess, were these the real reasons or were they pretext for racial discrimination?
So similar to what Justice Meyer asks, if the prosecutor right there on the spot would have had the words right there on the tip of his tongue to say, you know what, this man claims to have had a substantiated incident of law enforcement misconduct that victimized him, and it was substantiated. He has an adverse, I'm worried he'll have an adverse reaction to the law enforcement witnesses in this case just because they belong to that class of people there. Would that be race neutral?
I think that would be a very different set of facts and explanation to look at. And I think in this case, with the shifting explanations, with the lack of clarity, and it is important in Miller L. v. Dredke, the court in very similar scenarios found that these shifting explanations reeked of afterthought, and it ignored the pretextual timing of the stated reasons for the strike. But I do think that when you look at the record, at one point the court did say we can read back the record, but then allowed the prosecutor to state that one of the initial reasons was the negative interaction with police. And so I think the record reflects that the court did not carefully assess how these explanations evolved, and those were necessary in conducting this analysis. And I see my time is up, so I'll close.
Thank you, counsel. Ms. Hankey, you may proceed with your argument.
May it please the court, counsel. Justice Salter, you started this argument off asking Mr. Bluin what evidence or what was out there that suggests that the state strike of juror number 78 was racially motivated or racially related. And there isn't any, other than the fact that they are both members of the same minority group. When we think about racially motivated strikes, typically there's like a pattern of the state striking minorities. In past cases we've seen where where the state would strike a large amount or a large pool of the minority group. Or for
Kind of hard to do that when there's only two on the prospective panel, right?
two that we know of, Your Honor. As the state had pointed out, you don't necessarily know who is a member of that group.
So are we supposed to assume that there were more? I mean, how do you establish a pattern when, as far as everyone knows, there's only two
Sure.
members of the sort of suspect group involved?
So pattern can be certainly one of the things we look at. Some of the other things we look at is like suggestive questioning and whether or not like the state's questioning had some racially related undertones, giving them a reason for that strike. And here there was simply nothing else to suggest that this was racially motivated. When we look at the rationale the state gave, it's been classified as shifting explanations, but I would submit to you that it's not. When the state responded to the Batson challenge, it indicated it was based in part because of the juror's criminal history. And when corrected by opposing counsel said, I don't remember him talking about criminal history during voir dire. He talked about this negative interaction with law enforcement, and the state said, yes, I assumed they were related. Justice Kaczynski, you kind of hit on that a little bit, where the individual admitted to being thrown to the ground, handcuffed. And so it's not a far stretch for an individual to think that because the juror was handcuffed, it was related to his criminal history.
That one got cleared up pretty quickly. The prosecutor
Correct.
re-railed that right away and said, yes, what the defense lawyer said, that's what I'm talking about.
Correct, and that was consistent throughout the entire back and forth, if you will, with the court. The state never wavered from this negative interaction with law enforcement. I understand he may have classified it a little bit differently in his initial response, but that was the underlying reason throughout his entire presentation to the court. It was never changing or, suggesting an afterthought. It was consistent throughout this negative interaction.
Kind of. I mean, it was, there's the idea that there was a negative experience with law enforcement officers for Juror 78, which may or may not involve criminal history, particularly if you take Juror 78 at his word and he says, yeah, it was actually substantiated. They shouldn't have done whatever they did to him, handcuffed him, that sort of thing. So then that kind of gets, swamped around with criminal history. And this is the imprecision that Mr. Bluin's arguing about. And some of the question really is, if you do have maybe objectively something that's race neutral, could the state snatch defeat out of the jaws of victory by failing to articulate it well enough and being clear enough? And would that ever create clear error, or could it in this case?
Could it ever create a clear error? I mean, maybe if the state is more wishy-washy or not very articulate, but in this case, the state was articulate in its rationale. Like I said, it really kept to the negative interaction with law enforcement.
I asked Mr. Bluen about our deferential standard on a court's decision like this, and one of the things he suggested that might overcome that deference is the fact that the court seems to have misapprehended some of the circumstances of the juror's background.
Yes, Your Honor. So in terms of the court misremembering the records, so to speak, the court was present throughout the entirety of voir dire. It was also present, obviously, for the argument made by the state. And whether or not it remembered the state followed up, you know, the court said, well, the state didn't follow up, but it did. And so in reality, because the state followed up, I think that actually rules more in favor of the state, because the state did have follow-up questions to that negative interaction. It wasn't just, oh, you had a negative interaction, okay, let's move on to the next question. And so...
But the court also seemed to have some genuine concerns about the explanations and the way the state was making its explanations, and then perhaps seemed to maybe in the end say, well, it's a close call, so I give it to the state sort of thing.
Ultimately, the circuit court did what it was supposed to do in this case, and it evaluated the explanations and determined that a race-neutral explanation was given. And part of that is credibility of the state in terms of its rationale explained. And the court did its analysis in here. I know this court has seen a couple cases in the past where the circuit court kind of bypasses prong 3 of the Batson challenge or analysis. And that's not what happened here. The court did a full analysis, and it appropriately found the state's rationale was non-racially motivated.
Can you back up just a little bit on, I think for the first time on appeal, you make the argument that there was no prima facie case presented. Is that waived because it was never made down below?
It is, Your Honor, but I still stand by that there was no prima facie showing. I think there does need to be more than the jurors struck and the defendant belonged to the same minority group.
Do you get to raise that with us if you didn't raise it below?
No. No, this issue was not raised below in terms of whether or not the prima facie showing was made.
So it's really not something we can address either, because it wasn't preserved below.
Correct, Your Honor. There was also some discussion with Mr. Bluen about the state, or I should say, juror number 78 was rehabilitated during voir dire, saying, you know, this instance was 20 years ago. I can sit fair and impartially. I can weigh the evidence. But he was rehabilitated for a for-cause challenge. It would not have been appropriate to challenge him for a for-cause challenge based on that. However, when it comes to preemptive strikes, we do not have such a stringent guideline. In fact, the parties are pretty welcome to strike a juror for whatever reason they see fit, obviously racially neutral reasons, I should say. And so the fact that the juror said he could sit there and remain impartial does not mean that the state doesn't have a worry that the juror could still have some inherent biases against the state based on his prior interactions. And then I realize Mr. Bluen didn't get to issue 2, but if the court would indulge me for just a brief moment with what little time I have left. The state did not engage in prosecutorial misconduct in its closing arguments in this case. The phrase "we know" was used to marshal in evidence admitted at trial and the reasonable inferences from that evidence, which does not equate to improper vouching. When the state used the phrase "we know," it was merely reciting evidence that was presented at trial. And the state is allowed to highlight inconsistencies throughout its closing argument, which is the purpose of closing argument, is to point out inconsistencies and show what the evidence showed.
Yeah, this went a little bit beyond just highlighting evidence. There's multiple times where the prosecutor says, we know this, we know this. You know, for instance, we know the intent. We know he intended to cause her death. We know the result is guilty of murder in the first degree. Those are pretty strong statements on this evidence. And does that cross the line?
They are strong statements, Your Honor, but no, they don't cross the line. When you read them in the entirety of the closing argument, that was kind of what I would consider more of a closing, if you will. The state was wrapping up its closing argument and gone through what all of the evidence showed and was just really kind of hammering it home at the end.
But we know seems to express an opinion more than just the evidence shows this, the evidence shows his intent, and here's why, the evidence, as opposed to, we know. I know as the prosecutor, and you know as the juror now, because I'm conveying that to you and telling you, you should know based on this evidence.
But again, I think when you look at the totality of the argument, the phrase we know was used quite frequently, and there was no suggestion that the state had knowledge that a jury did not. It was simply a way to present the evidence without some sort of passive or clunky phrase like, I submit to the evidence shows.
Mr. Bluen cites a number of federal cases where the courts have been looked very disfavorably at using words like that rather than simply conveying the evidence and saying this evidence would convince you that he did this.
He does, and this court has also said recently in the Here decision that the state shouldn't be expected to use passive voice the entire time or to use I submit to you. So long that it is clear the state is arguing from evidence presented, it isn't improper.
So isn't sort of the key launch point for this area, the initial determination about who is we, right? Because if we is law enforcement and the cops and we know it and I'm telling you that, you've got a real problem. What if we is the collective group that heard the evidence?
That is how I interpreted when I read the closing argument.
Doesn't that mean
was the collective group in the courtroom, so to speak.
So we can't really necessarily have a categorical rule that says we is always bad. The pronoun, the
Correct.
collective pronoun, plural pronoun, we is bad. It seems to depend upon the context a little bit, or a lot.
I would agree with that, Your Honor. I think context is very important. And like I said, when I read through the closing, I interpreted it as the collective we, where the state was talking about himself and the jury. We sat through this trial together. This is what the evidence shows us.
Isn't that kind of a problem, though? Doesn't that get pretty close, maybe even crosses the line of the golden rule when the prosecutor puts himself in the jury or vice versa?
I wouldn't say in this instance the prosecutor put himself in the role of the juror. It simply stated what the evidence was that was presented and the inferences that can be drawn from that.
You said when you read the transcript, that's how you felt about it. But to me, the question is, how would the jury view it when the state says to them, we know he's lying?
Again, Your Honor, I think it depends on context. And like I said, in this context, it seems that it was more the collective we, as in the jury, not collective we, the prosecution team and the witnesses. Because the circuit court properly denied defendant's Batson challenge and the state's closing argument did not constitute improper vouching, the state respectfully requests this court to affirm Shangru's judgment of conviction. Thank you.
Thank you, counsel. Mr. Bluen, you may proceed with rebuttal. Well, on that second issue, assume we determine this crossed the line.
Yes.
Talk about prejudice.
Yeah. Certainly, you know, with the statement, for example, we know he's guilty of first-degree murder. I understand that the jury ultimately found Mr. Shangru not guilty on that count, but I don't think it necessarily resolves the question of whether the prosecutor's we know statements influenced the jury's evaluation of Mr. Shangru's mental state. The prosecutor said, we know his intent. We know he meant to cause death. We know he probably lied on the stand. Of course, I think intent in this case was certainly a key issue, a close issue in this case. There was certainly evidence in the record that Mr. Shangru had a hard time understanding what was happening around him, the staggering, the yelling out for his girlfriend, banging on a window in the parking lot, extremely intoxicated, described by one witness as not things he was saying were not making sense, trying to help EM off the bathroom floor. So I think it was a close question on intent, and I do think it crossed the line.
So if the state had said instead in its arguments, you know, instead of we know, wouldn't be a problem, correct?
I think that would be different, yes.
And so it's really about the context of we and how we is interpreted in these circumstances. And so what is it about this particular use of the word we that makes this one problematic?
Well, because these were on ultimate issues that are squarely within the province of the jury, and it's interjecting, I believe, a personal opinion or conclusion on these facts that were not known facts, and saying, you know, it really, I guess, improperly places the prestige of the government behind the assessment of the credibility, the intent, the ultimate guilt, and in that way, I think it did cross the line here.
Do you agree that this issue was forfeited?
Forfeited.
There was no contemporaneous objection. There was no objection whatsoever. So we would review it really only under plain error.
That's correct.
And we really only get to prejudice, which would be prong 3, the substantial rights determination, if there's one, an error. So let's say using we was not good. 2, it's plain. It's plain as day under the rules as they exist. Is there a rule that you can point to that says, this one is so darn clear the judge should have corrected it on its own, even without an objection? Is there that kind of a rule?
Well, I think if the prosecutor interjects his own conclusions, that this court in State v. Beck indicated that that error is plain. And I think that that's what happened here, and so I do think it was plain error.
I'll take you back to prejudice for one more moment. The chief asked that about it, and I kind of diverted you from it. So what about our traditional analysis is it made a difference? How do we assess that this made some difference? Without this error, without the state making these?
Yeah, and I think you have to look at the issue of intent and how close the evidence was on that issue, and whether that could have impacted the jury's decision related to intent, even if it meant the difference between, for example, manslaughter in the first degree versus murder in the second degree. That would be a different result. And so I think that the jury could possibly have been improperly influenced by those statements made by the prosecutor, and that it did make a difference in the result. I see my time is winding down here. I would just close in saying, taken together on the first issue, the circumstantial evidence of pretext and the state's reasons cannot be explained away by mistakes or coincidences. The numerous signs of pretext here were present, and the circumstantial evidence establishes that the reasons for the strike were pretextual. In the alternative, the trial court did not adequately examine the accuracy or plausibility of the state's reasons. And for that reason, we are asking this court to vacate Mr. Shangrew's conviction and remand for new trial. Thank you.
Thank you, counsel, for your arguments this morning. The case is fully submitted. We'll be in recess till 9:45.
This next song is written about losing someone that you love. Step outside with me and look for a star as we play Dust to Stardust.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
May be seated. Thank you. The second case set for argument this morning is State of South Dakota versus Tel Logan Cadat. Appeal number 31148. Matthew Marabella is arguing on behalf of the defendant, Mr. Cadat, and Roberto Nolasco Cruz, who is an intern, I understand, in the Attorney General's office, will be arguing, and Sarah Throne is present with him. All right, Mr. Marabella, you may proceed with your argument this morning. As you're doing that, let me just note that Judge Bobby Rank is sitting with the court this morning in place of Justice Robert Kaczynski. Judge Rank is a Sixth Circuit judge, and we appreciate her sitting with us this morning.
May it please the court, counsel, my name is Matthew Mirabella of the South Dakota Office of Indigent Legal Services. I thank you for your time this morning to speak on behalf of Mr. Cadat. Establishing the identity of the individual depicted in the photographs was crucial to this prosecution. Not only was part of the disclosure of the exhibits untimely, but at trial the state elicited testimony from AR and her mother, Tina, who's also Mr. Cadat's mother. Neither established the identity of AR in the pictures subsequent to their testimony, and identity being a core and highly contested issue at the trial. The state elicited unsworn out-of-court hearsay evidence from law enforcement to establish identity. There are two separate legal issues in this case, discovery and hearsay evidence. Both are intertwined in many respects. I'd like to first speak to the discovery issue and then use the remainder of my time to discuss the hearsay issue. With respect to the discovery issue, for background context, pre-trial, this trial occurred in 2025. In March, the original allegations were made in 2021. In March of 2022, the defense had filed general discovery motions as well as, most important here, specific requests of the tangible evidence, specifically photographs that were intended to be used as exhibits at trial. The response from the state came in October of 2024, where the notice of witnesses and evidence intended to be used was filed for the defense to review, and simply the notice from the state was all photos and then, quote, various images from electronic devices. And what's important for context with this case is that it surrounded hundreds of images that were at issue. It would be a different scenario had there been, say, for the sake of the example, 5 at play, and you tell someone we'll use all of them. That gives you more indication of really what you're dealing with, versus here we're talking about a lot of images, a very specific defense request, and then that was the notice that was provided.
Now, as I understood it, the state essentially has an open file policy here where the defense could go and review all the photos that the state had available. True?
Yes.
And what rule is it that gives the defense the opportunity to say to the state, tell me which ones you're going to use at trial?
Specifically, I would reference 23A 13.3, where we are talking about the request from defense asking specifically for the intended photographs that would be used as evidence in the case in chief. I would also note, and I think that this is really important for context in terms of the discovery issue, that despite the specific request from defense and then despite the kind of vague notice concerns here, the defense nevertheless in this case, and we have a clear record of that, did their due diligence as much as humanly possible to try to find out specifically what we were dealing with. The defense made a record. The first day was jury selection. The second day, at the beginning, before the first witness was called, the defense's record as to the discovery issue is recorded with specificity. And the defense had indicated on several occasions that they had visited the ICAC facility where they expected these images to be located. They were looking for the images, and specifically sanitized images, that Sergeant Walker showed to Tina Cadat, and they make a clear record on multiple occasions. I'm specifically looking at page 9 at the beginning of the second day of the trial, where they were given 4.
But it's clear from their interview with him that there were, with his interview with her, that he had showed her more than 4.
Yes.
And so they knew there were more than 4. Did they do anything to say to the state, hey, we know there's more than 4, but we were only showing 4?
I don't think the record reflects further specificity as to any additional steps from there. What we have for record purposes is the pretrial requests, the notice that was made, and then the record that there was this action on the part of defense counsel for due diligence to go and find this out. And it was their anticipation that they would be dealing with, we knew there were 13 total counts, but their anticipation is that many of those counts would be limited to credibility of the testimony, which.
I'm sorry, go ahead, please, finish your thought. I didn't
Go
mean
ahead,
to
Justice Salter.
Well, so your theory about the discovery violation rests with 23A.13.3, and I'm sorry I missed it, and you explained it earlier. What provision of that statute imposes an obligation? This was in response to Justice Myers' question. What part of that statute imposes an obligation for the state to have furnished the defense with these photographs?
The statute at issue makes clear that essentially at any time, and this time I think we have the most problematic time that this could happen, which is in the middle of the jury trial taking place. At any time that there's an issue raised as to discovery, then there are a couple options that the court has to do with that in assessing it. And I would note here too, is the record is lacking in terms of a specificity of the request from the defense.
Hang on just a second. So I want to know what provision of the statute imposes the obligation on the state to provide the defense with what you think the defense should have received.
That the specific discovery statute doesn't give us further information directly to what you're asking.
So that's important though, right? Because before we could get to the question of whether there's a proper remedy or whether the court, did something correct in terms of a remedial response, you have to determine that there's been a violation of some sort. That's kind of a predicate showing. And so how is it we get to that? I mean, how can we get to your argument that the court should have done better or done something different in terms of the remedy that it fashioned? The time wasn't enough to review something, whatever, if we can't first find a discovery violation.
And I think the violation stems from the objection from the defense that this was not disclosed or made available. And availability was the ultimate ruling from the court, and that's the argument from the state, is that these things were available and therefore there's no issue whatsoever. The issue is that they were not made available or known until the morning of right before the first witness was
I'm sure
called.
that's right. I think that as I read the record, it sounds like they were absolutely available. These are contraband images, and so they're maintained at a separate location. And all of the images were available in unsanitized form. As it happens, as I understand it, the sanitized ones were as well, although perhaps the defense lawyer didn't know exactly where to look to find them. That much might be true. But it seems like they were all available. Am I wrong on that?
I think that the record reflects that there's some uncertainty about that from the record that was made by the defense.
The trial court judge asked actually a question really similar to the conversation you're having right now with the defense counsel. And so when defense counsel kind of said, hey, this seems unfair, there's this binder, and I really wasn't aware of all these unsanitized images. And of course, the unsanitized or the sanitized images are the same as the unsanitized. They just have certain portions that are redacted. It's the same photos though, right? Are we in agreement on that?
Yes.
So the trial court judge says, okay, what's your theory that this is wrong? And as I read the record, there wasn't really a clearly articulated theory as to what was wrong with what the state, or what was wrong.
Essentially, and I want to move to the second issue after addressing that. The crux of the issue is that the record from defense is that they didn't know about this and it wasn't made available to them when they had tried to go find out the specific information from ICAC. But if I may, in the interest of my time, move to what I think is the more important issue, which is the second issue.
Does that mean you're not going to answer my question? Because I don't think you can do that. I want to know, is that a clear expression by defense counsel that would preserve an that the state had done something wrong?
I think that what we have is a clear record that there was a written request for this information and that it was not provided and noticed and also not available to them. Moving to the second issue, which I believe to be more significant, because it's one thing to be discussing how many pictures we have. Identity was the core issue of this trial, and so whether we're talking about 4, or in this case, what was argued later, 9 specific instances of documented first-degree rape to support the first 9 counts, I think the hearsay issue is where the crux of the case lies more importantly. So the first piece, and it doesn't end the inquiry because we must talk about prejudice, the first piece is establishing that it is hearsay. The Attorney General's argument and the state's argument, well, there's not a record from the state at the trial that they had argued this, but the Attorney General's argument is that it was not offered for the truth, specifically the statement from Sergeant Walker as to what Tina had told him with reference to identification. It was offered for investigative steps and action as to why he did certain things, and it was not offered for the truth. I would first note that Sergeant Walker, his testimony just prior, it's on the same page, 171 of the trial transcript, where both the hearsay issue takes place as well as the purpose stated right before that. So Sergeant Walker himself tells us that I was showing her the photos to try to get a positive identification. So we hear directly from the witness that this was the purpose. There's also some conversation about attempting to get another warrant, a second warrant, which I'd like to get to that in a moment because that's important too. But the primary purpose was for identification, not for Sergeant Walker to do something else.
So in the context of how the whole trial went down, and so the witness said that she was Tina, right?
Yes,
So she testified before the officer, correct?
she did.
All right, and weren't these same sort of questions that were posed to her related to her again at trial? So the jury had already heard through her direct and cross-examination what she did or did not tell the officer about the photos she was shown, correct?
What the jurors had heard from Tina was being asked many different times about identity and giving a lot of unclear answers to that, which is an entirely different statement than what we're dealing with Sergeant Walker, which was a much more definitive and declarative assertion of identity. Tina Cadot's testimony, she was asked on multiple occasions. I'll just summarize some of the most important pieces there, where she was asked, do you recognize the individual wearing the blindfold in this photo? The answer, it looks like her. Why do you say that? The long hair, I can't really tell. On redirect in particular, at page 95, she was asked again about identification, and the answer was, I mean, even these photos, I just don't really know if that's AR, my daughter. There was not conclusive testimony. It was speculative. It was questionable on multiple different times where she was asked about this.
So your view of the case is that without the officer subsequently saying, yes, she identified her as the victim, that the jury would have used the evidence of the mother's testimony and concluded, no, she'd never identified her as the victim.
In terms of prejudice and reasonable probability of having an impact here, if you remove law enforcement giving more definitive assertions of identity, there's also a comment later from expert Strand, who primarily her role here was conducting forensic exams of the electronic devices, but she had made a statement as well indicating, so once we had identified AR in this case, we being law enforcement, she had reviewed the photographs with Sergeant Walker, and there's a testimony in the record of that. If you remove those things from the case, then what you'd be left with is AR's testimony and Tina's testimony primarily. AR was not shown the photographs to identify herself. There wouldn't be evidence of identification from her. And then as I had outlined in regards to Tina Cadot's testimony, there were a lot of questions with that. So the jurors would...
So AR said, this is what he did, this is how he did it, he blindfolded me, and I could hear him taking pictures, and I could hear the clicking of the pictures being taken. So that's some pretty direct evidence that she is, to your point about identity, that would serve, and we're not doing sufficiency here, I understand that, but that seems like direct evidence of identity.
And I think this is where the verdict that was rendered becomes important. So had there been convictions of the last two in particular where there were acquittals of first-degree rape. One was thrown out on motion of judgment of acquittal based on AR's testimony being concerning in terms of not specifying how often this, the answer was, I know that this happened more than 10 times, but I don't know. There was also an issue from AR's testimony where she couldn't even identify her brother, Mr. Gadad, in the courtroom as well. So you have questions there that the jury acquitted of specific first-degree rape allegations that were based exclusively, as the state argued, on her testimony. So you have these questions from the testimony itself that the verdict shows that there were questions about that, which leads to it being reasonable probability that what was relied upon were these assertions that the jury should not have heard as to identification from law enforcement witnesses. I see that I am just about running out on time, and I'd like to state...
Can I say one thing really quick? The 9 photos, there's 9 unsanitized photos. They may well correlate to the 9 verdicts for first-degree rape. There was no objection to the 9 unsanitized photos coming in.
With respect to coming back to the discovery component?
Well, so there was, as I understand it, there was a objection initially, we talked about that, about the sanitized photos. But of course, the sanitized photos are sanitized versions of the contraband images. There's 9 contraband images that came in through probably Holy Strand. And she talked about them anyway. There was no, yeah, they came in through Holy Strand. There was no objection to those 9.
The objection was to the binder of 70 at the beginning of the second day of the trial, which included, that's where the 9 come from that binder.
When they came into trial, there was no objection.
I believe there was a standing objection from Ms.
The
Regalado.
sanitized photos.
Yes,
as I read it.
to all of them, and I believe...
But of course, the sanitized photos were sanitized in such a way you couldn't see the sex act and they wouldn't be evidence of a sex act.
There were certain parts of the images that were blocked out, but they depicted the conduct that was later argued by the state, that we have 9 showings, direct pictures of showing first-degree rape occurred on 9 specific occasions.
Thank you.
Mr. Mirabella, I know you were going to say something before that last question. If you want to wrap up with that, you can do that.
Thank you, Mr. Chief Justice. In summation, the trial court erred by not providing a reasonable discovery remedy in the middle of the trial, and also erred in admitting hearsay evidence over objection, and the verdict rendered establishes probability that there would have been a prejudice and a potential different outcome, and he asked for a remand and a new trial. Thank you.
Mr. Velasco Cruz, you may proceed with your argument.
Thank you. Mr. Chief Justices, counsel, may it please the court. This case concerns 2 discretionary evidentiary rulings by the circuit court. First, the admission of photographs the defendant claims were disclosed too late, and second, testimony from Sergeant Walker explaining crucial steps in his investigation. These issues are reviewed under the abuse of discretion standard, which is highly differential. The circuit court acted within its discretion because the photographs were disclosed to Cadat and made available to inspect well before trial, and Sergeant Walker's testimony provided necessary investigative context and was not offered for its truth. And even if this court finds error, Cadat cannot show prejudice. And for those reasons, this judgment should be affirmed.
When the defense makes a request and says, we would like you to tell us all of the exhibits that you plan to use at trial, does 23A13.3 require the state to provide that to them?
It is from my reading of the statute that no, it doesn't require specificity. It just requires the state to make available the inspection of in this case, the photographs, and that was done in this case. The state made available those photographs. Defendant had access to ICAC to the unsanitized photos and the sanitized photos as well that were used by Sergeant Walker in his interview with Tina. So under the statute, the state's only obligation was to permit the inspection of all the photos that it intended to use, not that it was going to use. So there is no language that.
So I thought there was some indication by defense counsel that maybe they didn't have access when they were there, or that the binder was not in the file at the time. Can you speak to that?
From my reading of the record, it sounded like there was a procedure in place where the binder was checked out at the time, based off of the record.
Defense counsel have known that if it was checked out?
Not to my understanding. The record doesn't reflect whether or not they knew. They never made any comments about knowing or not knowing whether the binder was checked out, but it doesn't overcome the fact that there was notice given to the defense counsel.
So were there two different binders? Because the defense said that they saw some of the redacted images, I think 9, but there were more than 9, which they knew from the interview. So what was checked out? Were there 2 binders?
Not to my understanding, the record doesn't indicate how many binders there were. From my understanding, the unsanitized photos were kept in a binder. From the record, it shows that Holly Strand was the one who came from ICAC with the binder on the second day of trial. But I believe that the photos that defendant had 4 copies of were from Sergeant Walker's interview with Tina, and that's where I think, and again, the record doesn't provide adequate.
So if there's some uncertainty in the record about that, how should we resolve that? How do we deal with the fact that maybe we don't know for sure whether there were some of the pictures that would have routinely been available but weren't on that day or something like that?
I would believe that the statute would be the guiding principle there, that the photos were made available. Again, the record indicates, even in defense counsel's initial objection to the photos, making statements that they were provided the search warrant and items of that nature, which would indicate that they were made aware of Sergeant Walker's interview with Tina, where he made statements of there being 23 images that he showed her. So there is the notice that only having 4 photos in hand, it doesn't really align with the record. The record shows that there was more than.
And we're talking about photos, sort of creating this distinction between sanitized ones and unsanitized ones. But in truth, the unsanitized photos are just a class of, the sanitized ones are just a class of the very same images of unsanitized visions, or images, excuse me. It's the same photos, right?
Correct.
They've just been redacted or altered in some way to make them less contraband or less egregious in their appearance.
Correct, and the record also reflects that the defendant had access to both, both the unsanitized and sanitized versions, the unsanitized at ICAC and the sanitized versions that they were provided from Sergeant Walker's interview with Tina.
Let's talk about that. Why is it, you've heard the argument, read the argument, responded to the argument about the hearsay claim there. And what's your view in your response to the argument that this is really hearsay testimony?
So for the interview, it's this state's position that the statements weren't introduced to identify AR in the photos. There's testimony both from Tina, where she made the identification of AR herself. She was presented the photos, and she articulated that on direct that in the photos it does look like AR, and then she was able to articulate items that were in her own bedroom, like the dream catcher in the mirror. But also, even on direct examination or cross-examination, she was able to articulate that the photos that Sergeant Walker presented to her, in those photos, she was able to also not identify AR, because the point of Sergeant Walker's investigation, which he also testified to, was to differentiate between the photos, because as Holly Strand testified, that there was a belief that these images were produced by Cadat, but in order to, there was difficulty in identifying AR, so Sergeant Walker interview Tina to help differentiate between the photos that may have contained AR and photos that may not have contained AR. So to answer your question, in his testimony, because even in the testimony that, even in the transcript, again, I would refer to page 171 of volume 1 of the jury transcript, the full context of Sergeant Walker's testimony was to try to positively identify the young female and to attempt to locate any other evidence to corroborate where and who may have taken these photos.
Did he in fact follow up with that second objective?
He did. So using this interview and using Tina's positive identification of AR, he was able to obtain a subsequent search warrant. And in that search warrant, he was able to locate the sleeping masks that were then introduced into trial. He was able to find items in that search warrant that were able to corroborate not only what Tina was testifying to, but also what AR was testifying to, that she was blindfolded during the sexual acts, and that and the items of clothing, the bedspread and all that stuff. So
And the jury received all that information, correct?
yes.
And so it was helpful to the jury to know how he came about gathering those pieces of evidence.
Absolutely, because in the grand scheme of according to the record, in the grand scheme, the jury was introduced to, there was hundreds of photos that were taken from the devices from the initial search warrant, and so it was to establish like how, from my understanding, how the investigation went from over 300 photos down to these 12 photos that were presented in front of them, and why it was necessary to identify so that Sergeant Walker was able to then obtain the second search warrant, which led to further evidence to corroborate testimony.
Sometimes, though, evidence can go to both purposes. It can go to explain the investigation, but it can also go to the truth of the matter asserted. Does the evidence in this case have both functions?
It could have both purposes, but I think in this situation, again, when you take the totality of the circumstances of Sergeant Walker's testimony, it was to give clear indication of his purpose and intent to get the identification. It wasn't to confirm that Tina identified AR. It was to specify that he needed to determine which photos were potentially manufactured by Kadat and which photos weren't, so then he can continue his investigation, which again, the record shows that he was able to successfully obtain the second search warrant, which then led to the tangible evidence that was presented at trial. So from my understanding, yes, but in this context, that wasn't the intended purpose. It was to, because again, even during his cross-examination, he specified that Tina was able to identify AR, but she was also unable to identify that some images weren't related to this case or this circumstance. So I would think that the context of Sergeant Walker's testimony in its entirety, again, it's also cumulative to Tina's testimony, where she was, and then that goes to the State v. Osmond case, where in that case there was no cumulative evidence, there was no way to correlate the officer's testimony to any other testimony, but here Sergeant Walker's testimony directly relates to Tina's identification. She was able to identify that AR was in those photographs. She was able to testify that she remembers pointing out that Tina was in those photos. And then, excuse me. And then, so going back to the first issue, it's of the state's position that the photographs were disclosed on time. There was no excuse me. because I want to touch on if this court were to determine that there was an error, was there prejudice? Under that review, there would be no prejudice because
Justice Salter noted that the unredacted images were admitted without any objection from the state. How does that affect the analysis in your mind?
then if there was, and the record does reflect that when the unsanitized photos were presented, especially it was during it was before Holly Strand's testimony, when the circuit court allowed 15 minutes to review the photos, there were no objections to the photographs. So in that instance, then the argument is waived. They waived their.
I want to say they were like 28 to 36 exhibits, 28 to 36, somewhere in there, am I
26
right?
to 38.
Was that right? Was
26 to 38, I believe.
26 to 38?
Yes, there was 12 total exhibits.
Okay.
But to go back to your question, yes, I would believe that because there was no objection, then they didn't preserve their right for review. But in that instance, there was still.
But how does it affect your prejudice analysis with respect to the redacted copies? I mean, if the unredacted ones came in, the uncensored ones came in without objection, can there be any prejudice with the others?
I don't think so, no, because the defendant had full access to the photos. There's the record reflects again that they had access to the photos. They weren't provided last minute. They had 4 copies of the photos of the sanitized versions of the photos. So there is no prejudice, but if because again under the prejudice analysis would but for the error the verdict be different? It seems like because of all the overwhelming evidence presented at trial, AR's testimony, Tina's testimony, Sergeant Walker's testimony, Holly Strand's testimony, and all the other testimony, and all the tangible evidence, it doesn't appear that the defendant was prejudiced, would have been prejudiced by the admittance of the photographs. So in closing, under the abuse of discretion standard, the circuit court's rulings were well within the range of possible choices. In that we would ask that for these reasons, and we would defer to the state's brief, that the state respectfully ask the court to affirm the conviction and the sentence. Thank you.
Thank you, Mr. Velasco-Cruz. Mr. Mirabella, you may proceed with rebuttal.
Mr. Mirabella, while we're all together, I just want to make sure I've got the record straight, and maybe you can help me. So the sanitized, redacted photos to which there was a standing objection were exhibits 5 through 8. And of those, exhibits 6, 15, 16, 17, and 18 came in. So 5 came in. The rest were, based upon Tina's testimony, were neither or maybe Detective Walker. I think it was Tina or Detective Walker's testimony. They weren't offered and they didn't come in. So it's 5. There was a standing objection to those. But the unsanitized were exhibits 28 through 36, and there was no objection to those. In fact, they had the numbers wrong. They originally said 28 through 34. The judge corrected that. It's 28 through 36. Still no objection. Defense counsel, still no objection. So those are in. Would you agree with me on that?
Yes.
Without objection?
Yes.
And of the 5 sanitized photos that came in, we know from defense counsel's remarks at the beginning of the trial that she had seen at least 4. Now, we don't know if the 5 that came in were included the 4 that she had seen and maybe leaving 1 that she hadn't seen. But when I look at prejudice, I think that the record is so imprecise, it's very difficult to know, 1, whether it matters at all because the unsanitized photos came in, and 2, even if we look at the sanitized photos, only 5 of whatever binder might have been there came in, and at least defense counsel said, I saw 4. So, but we don't know if they were the same 4, or they were encompassed within the 5. We don't know what the 5 were. We don't know what the 4 were. How can we even review that?
The discovery issue is much more difficult to evaluate. And I think the record is confusing about a number of the components of it as a general matter. And that's why, and again, that's why I submit that the most important issue here is the second issue, because again, depending on the quantity of pictures we're dealing with, all of them tie to the same issue, which is with respect to identification, and that was the highly contested core issue at trial.
So are you abandoning the first issue?
I am not. I think that it's difficult to assess the record. What we know for sure we have is clear assertions from trial counsel that there were things that they did not have until the morning, and then there's confusion about a number of other areas in terms of availability.
Difficult though it may be, we have to do that. So help us out. How do we assess that record, even though it's difficult to do?
I think the issue boils down to a record from trial counsel that they did not have all of the information with respect to all of the pictures that were intended to be used, right? To boil it down to its crux. I'd like to address with my remaining time, if I may, again, what I submit is the most important issue for both. The issue itself in terms of step 1 for hearsay, and then also the prejudice component, as this case centered around identity. First, with respect to it being submitted that it was for the context of law enforcement investigative action, Sergeant Walker's role in this case was limited to gaining the initial disclosure from Tina Cadat, then scheduling the forensic interview so that the child could be properly interviewed by the relevant professional, drafting the first search warrant, assisting in executing it. That was done to specifically get electronic devices. It was during that first search warrant where Sergeant Walker viewed the belt at issue that was described as possibly belonging to Mr. Cadat. And with reference to the argument that he needed to produce this hearsay statement so that he could further his investigation to go get the belt, he had already observed the belt himself. He had reviewed the photographs with expert Strand. If we needed to get another warrant for it, he could have done that without this information. In addition to his role showing that it was offered for the truth and non-investigative action, he also says that this was his purpose. Tina Cadat also says that the purpose she was being showed these things was for identification. And then in terms of prejudice, if that is determined to be hearsay, in terms of prejudice, the impact is that if you remove the law enforcement assertions that were with respect to cumulative, they were not cumulative of the same character, they were more definitive declarations, then what you are left with, I see my time is up, may I briefly conclude?
Go ahead.
What you're left with without those law enforcement assertions of identity is testimony that is speculative, and from the verdict we can see that the testimony of AR and Tina was not exclusively relied on, as shown by the acquittals of particularly the final allegations of first-degree rape. Thank you.
Thank you. The court will be in recess until 10:30.
He has loosed his faithful lightning of his terrible swift sword. His truth is marching on. Glory, glory, hallelujah. Glory, glory, His truth is marching
This next song is written about losing someone that you love. Step outside with me and look for a star as we play Dust to Stardust.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
You may be seated. Thank you. The next case set for argument this morning is State of South Dakota versus Lucine Celestine. It's appeal number 31116. Matthew Marabella will be arguing on behalf of the defendant, Mr. Celestine, and Renee Stelliger is arguing on behalf of the State of South Dakota. We have sitting with us this morning Second Circuit Judge John Sohn, who's sitting in place of Justice Robert Gazinski. We appreciate his willingness to sit with the court today.
Thank you.
With that, Mr. Marabella, you may proceed with your argument.
May it please the court and counsel, good morning again. And I thank this court for the time to speak on behalf of Mr. Celestine, who asked this court to reverse and remand to allow him to withdraw his Alford plea and proceed to a second jury trial on the merits of the case. Pre-sentencing withdrawal motions are to be liberally granted, and the totality of the considerations here for Mr. Celestine weighed heavily in favor of withdrawal, with the two most important factors establishing the fair and just reason threshold requirement being innocence of the crime, as well as mental health considerations, which ties into the factor of the context of knowing involuntariness of the plea. I would like to spend most of my time on those two considerations, as I believe those are the most important, and then I will touch on the other relevant factors in the analysis.
So one of the problems with the innocence claim, as I see it in the record, is that when the trial court inquired and said, tell me about your innocence claim, there was really no articulation of what that looks like. I know there is on appeal in your brief. You talk about the fact specific intent. That was never raised, was it, in front of the circuit court?
The evidence where it does not a bare assertion for innocence, which would not be sufficient, and that part is made clear, comes from Mr. Celestine's words that were the evidence used at trial against him is what establishes his innocence from his own statements, which the record well reflects, particularly the trial itself. So Mr. Celestine, essentially, the evidence from the witnesses at trial, he's telling everyone what the defense is and why he is innocent of the specific intent statute.
But when he makes his motion to withdraw his plea and the judge says, tell me about your innocence, he just says, I'm innocent.
Yes. The rest of the record, which primarily including his statements, is where I submit that he is submitting.
But that shouldn't be surprising. It's an Alford plea, right? No one should be really all that surprised that he doesn't have a lot to say about actual innocence because he never truly pled guilty in a traditional sense. He entered a guilty plea, but unlike so many other defendants, he did not affirmatively acknowledge factually his guilt. And one of the things that I wonder about when we look at that factor is whether we're really assessing the contrast between a defendant at a change of plea hearing who says, I'm guilty, here's why, here are the facts, I am really, really guilty. And then later seeks to withdraw the plea and says, I am really, really innocent. And this factor, to me, is designed to let the court assess the contrast between those two. But it falls apart a little bit for Alford pleas because the defendant maintains his innocence throughout. Is that factor even all that important in a case like this?
Yes, and first, to be clear, as many cases, including State versus Engelman, which I'll talk about with another factor later, makes clear there's not an automatic right to withdraw just because you're doing an Alford plea, and I'm not suggesting that that's the case. That being said, with that caveat, I am suggesting that we should, in terms, again, of the ultimate framework of liberally granting these motions, pre-sentencing, post-sentencing is a different situation. We start from a liberal granting perspective of the totality of the lens, but if he pleads via an Alford plea, and what that is obviously maintaining his innocence or unable to admit facts that make him guilty, then I think that should be relevant to the overall assessment. Again, not an automatic right to withdraw just because you've done that type of plea, but the fact that he did not come in and state his factual guilt, and then looking at the statements that he made from the trial that we had, I think is relevant in terms of the innocence factor, showing that we have a plausible assertion here. And again, the requirement,
But Engelman seems to suggest that that inquiry of innocence really doesn't have much, and to Justice Salter's point, doesn't have much fortitude when you've already entered an Alford plea and said, I'm innocent, but there may be enough evidence to convict me in this case. And it seems like Engelman kind of said, you know what, you can't really come in and claim innocence on a motion to withdraw a plea when you've entered an Alford plea and already maintained your innocence by nature of your plea.
and I think the main principle from Engelman with respect to that is that it's not an automatic right. And what the totality of the case law addresses with...
So in other words, you need to have pretty good evidence or some basis to come in and say, because it's now your burden of proof as a defendant, to come in and say there's a good and just reason to allow me to withdraw my plea. It's your burden to prove that, and there isn't really anything here that he presented to the trial court.
Lucian specifically at the change of plea hearing made no statements about the case whatsoever. So at that hearing, there's not the evidence in the record asserting the innocence component. The primary piece that comes from is the trial that we had in 2023, where from his own words, we're hearing the innocence of him that we submitted and argued at trial, that he is lacking this specific intent. So I think that is where it's not a bare assertion.
But he didn't even say to the court, hey, look at what I said at the trial.
Right. And I think, I'm going to speak to mental health as well, and I think that is part of the issue here in terms of his understanding of what's going on in the proceedings, and he was found competent. That part was made extremely clear. But in terms of the mental health aspect of this case that I think is difficult to ignore in terms of both innocence but then also the knowing involuntariness issue, it's difficult. For example, when he is asked for his plea, he says, I accept the benefits of these charges. It doesn't make sense. It calls into question his understanding of what he's doing and making that reasoned choice to plead and going through that.
Let me ask you, do you see a difference between a claim of actual innocence and having what you think might be a good defense to the crime? Because I'm not so sure. I think there might be a difference there. If you look at actual innocence as factual innocence, I did not do this. I am factually innocent. That seems different from the argument that, oh, I did all the conduct, but I actually have a defense. I'm not sure that having a defense is the same thing as actual innocence. What do you think?
I agree that those may not be completely connected as the same. For Mr. Celestine, what he has is assertions from his own himself that he can't possibly meet the specific intent requirement of the statute and an essential element of the case. And his own words are what gives us those facts, showing that and I think that one of the issues with the innocence factor to address is we're talking about a plausible defense to the charge. The circuit court's analysis is not to decide, it's not a court trial, it's not to decide if it's a winning argument, as one of the cases I put in my brief discusses. It's to see if this is legitimate to take to a jury. And we know it was because we already did that about 1.5 years before the plea. Mr. Celestine had already submitted from his own words, the jury heard everything that he said, and I think that throughout this case, the evidence has shown that he is essentially entirely missing this element of the crime, for example, to point to some of the components of the record.
So I just want to stop you there a minute. This is kind of where we started out here. It appears to me that what you're doing here is really challenging the court's acceptance of his Alford plea to begin with. But this isn't, the issue on appeal is whether the court erred in denying his motion to withdraw the plea, right?
Yes.
So this isn't just a straight up, this isn't a challenge to the court. You accepted a factual basis based on the record that doesn't meet all the elements. That's not where we're at right now. Right now, the argument on appeal is, did the court err in denying the motion to withdraw the plea? So all the stuff you're talking about right here, none of that was provided to the court in the written motion to withdraw the plea. And as noted at the beginning of the argument, the court says, okay, what else do you want to, want to make a further record? What do you have to say? And it was, no, we'll just rest on what we submitted. So how do we now fault the court for not making a determination about what you're arguing here is a lack of one of the elements that needed to be proven when you didn't present that to the court as a reason for why he should be allowed to withdraw the plea because he's now claiming innocence?
So we're not challenging the factual basis, although I would note from review of the change of plea hearing transcript, there isn't, and again, because it's been missing in the evidence of the case as the trial demonstrates, there isn't a clear assertion of what the specific intent that qualifies is in the record. The factual basis was laid by defense counsel. Mr. Celestine, because he's doing an Alford plea, didn't make any other statements. So in terms of what the evidence was at the change of plea hearing, the political evidence, the political nature of the evidence isn't there either. But the primary piece of the innocence component is that his statements were made to a jury. They evaluated this specific issue and
I understand all those arguments you're making, but I come back to my question. None of that was presented to the circuit court at the hearing to withdraw the plea.
Yes, and what the circuit court was not presented with at the change of plea hearing was political evidence to support the specific intent requirement.
Engelman rejected the actual innocence claim. What swung it in Engelman was the defendant's mental health, voluntariness of the plea. Talk about that. I know that's your other basis for claiming the court erred in the denying the motion to withdraw the plea.
Thank you, yes. The other component in terms of context of knowing involuntariness, specifically mental health concerns. Mental health concerns relate to the innocence factor because of the voices in his head and how that's really what the lack of specific intent is about. But it also is the crux of some issues here that I think is a separate independent reason for fair and just reason to establish the withdrawal. So this record is from 2019 because the way this case starts, it was State's Exhibit 1 at the trial, was a phone call from September 1st of 2019 that Mr. Celestine made to the FBI talking about voices in his head and what they were telling him to do. The CIA was reading his mind, things of that nature, and then all the way persisting through 2024 where the case begins to conclude, where the change of plea happens in November, and then in December we have the withdrawal hearing. And the record is replete with concerns, similar concerns, I think more grave concerns than what State versus Engelman presented. And I would just note a few pieces of the record and then tie it back to that authority. In 2023, during the pretrial litigation, we have a record that Mr. Celestine is diagnosed with schizophrenia. The state had attempted to motion limine to keep that out. There had been motions made at many times, including August 1st of 23, where Mr. Celestine desired to represent himself. And the court's record there with respect to that, I think, ties into the mental health component where the court explains, I don't believe that he understands what he's doing, and I strongly believe he's not intelligently waiving his right to be represented. Now, that's in the context of the right to be represented, and then that comes in again at the withdrawal hearing where it's discussed by the circuit court that his mental health concerns are too severe, is diagnosed, not that there is lacking evidentiary support, which was the case of State versus Schmidt from this court, where there was really lacking evidence that we had these mental concerns. Here, it's all over the record for many years, and as the court discussed at the withdrawal hearing and assessing, talking about his desire to represent himself, but it's in the context of the mental health component. The court discusses that there's no dispute in this case that Mr. Celestine suffers from a diagnosed mental illness, and that's all part of the record. The court listened to evidence of his mental illness at trial. All of the parties agreed that this was a reality in this case, and then the court specifically discusses a letter that he wrote right after we had the first jury trial where he was opposing the state dismissing his case, and as it was described by the circuit court, that this is the very height of someone who does not understand what is going on. So from the date that the first phone call is made to the FBI, where there are clearly these mental health concerns, with the voices in his head and what's going on, and then through all of the litigation of the case, before the first trial, during the first trial with the evidence presented, and then after that, including a year and a half after that, where these things are still going on.
So the court never should have let him plead guilty. Is that your argument?
My argument is that this is a consideration for, again, the framework of.
And I agree with Justice Devaney. I don't think that's the order we've got in front of us, but is that really where this leads to you?
No, not that, and it's his choice to plead. And he was found competent in these proceedings, and it's ultimately his call. It's not up to his attorneys whether he wants to accept what he was offered, which was an attempted terroristic threat plea for a recommendation of credit for time served. But what we have then is factoring in the mental health component for his quickly deciding to request a withdrawal. So not that he shouldn't have been allowed to plead, but factoring in if he understands the choice he's making. I see that my time, if I may briefly conclude.
Go ahead.
Thank you. Primarily for the reasons of mental health concerns, as well as, most importantly, I believe, the innocence assertion, Mr. Celestine asked this court to reverse and remand to allow him to withdraw his Alford plea. Thank you.
Thank you. Ms. Delager, you may proceed with your argument.
May it please the court and counsel. The sole issue on appeal is whether the circuit court abused its discretion in denying Celestine's request to withdraw his Alford plea. On the first day of Celestine's retrial, he indicated he wanted to waive his right to trial and plead guilty pursuant to Alford instead. The circuit court accepted his plea, finding that a sufficient factual basis existed. 20 days later, Celestine moved to withdraw his plea, arguing he was factually innocent and that he was previously denied his right to self-representation. South Dakota codified law allows a defendant to withdraw their guilty plea prior to being sentenced, but this court has held that a defendant must show a fair and just reason for doing so. In this case, the circuit court denied Celestine's request to withdraw his Alford plea, finding that a fair and just reason was missing. First, the circuit court held that it had previously properly denied Celestine's request to represent himself. The circuit court noted that a defendant has the absolute right to represent himself based upon a knowing and intelligent waiver of that right. However, Celestine's mental health, coupled with the bizarre understanding of his rights, especially his desire to oppose the dismissal of the action against him, rendered him not competent to conduct his trial. Further, the circuit court found that Celestine's claim of actual innocence was just a conclusory claim asserting that he was innocent. As this court has stated, self-serving testimony, much less simply a conclusory assertion proclaiming innocence, is not a persuasive basis to allow a defendant to withdraw a guilty plea.
Is there a difference between actual innocence and a defense? In other words, someone pleads guilty, they think about it, a couple days later they say, I've got a really good defense, should have asserted that. That seems like a really good defense, as opposed to somebody who said, I never did any of it. Is there a difference, or is it too fine of a distinction?
I agree with you that there is a difference between those two.
How does that factor into, and I don't want to get too formulaic with these factors, because in the end, it is a good and a just reason. The factors are helpful, but how would that play into our consideration?
Yes, in this case, in the Schmidt case that this court had previously ruled on, it held that actual innocence is the factor that should be considered. While this court has not defined what actual innocence means in this context of a change of a withdrawal of plea, it has held in other contexts that actual innocence means factual innocence, not mere legal insufficiency. In this case, he's alleging that he lacked the specific intent necessary for the crime, which would be a claim of legal innocence, not actual innocence.
And people give up those arguments all the time when they plead guilty, Alford or otherwise. I've got a defense, I'm not willing to risk it, and so I'm going to take the benefit of this plea agreement.
Correct, Your Honor.
So a couple other factors that the court has traditionally looked at is the delay between the plea and the request. Of course, it came very quickly here after the plea was entered. Prejudice to the prosecution. The court found both of those really favored the defendant in this case. Are those factors alone enough for a fair and just reason to to withdraw a plea if there's no prejudice to the state. We've said these should be liberally granted, where there's no showing of prejudice or the court doesn't find any significant prejudice or delay between the plea and the motion. Is that enough?
No, Your Honor. Celestine's quick timing of the 20 days between his change of plea and his formal request to withdraw does not equate into a fair and just reason to withdraw his plea. And this court has never found that timing alone is a fair and just reason. Regarding the prejudice to the state, the circuit court did find that the passage of time risked witness availability. So the circuit court did find that some prejudice to the state would be had if it allowed.
It doesn't seem like actual prejudice. It seems like maybe the potential or the possibility that there might be prejudice. I'm not sure that's prejudice. That just seems like there could be prejudice, maybe.
Correct. That it is.
But that's kind of like not having prejudice, but
Sure.
maybe there could be at some
Sure.
point.
And lack of prejudice alone is not enough to mandate withdrawal. There must be a fair and just reason. And this court has held that in the Koplecka case specifically.
But it's a totality of the circumstances assessment. It's not as Justice Salter would call it, a divide and conquer argument. I mean, just because each one is maybe not good enough, they could have all gotten together and been enough, right?
Correct. Yep. Fair and just reason under the totality of the circumstances.
The state never argued that we've lost a witness or something like that,
No,
right?
or any specific witnesses that have moved away or specific evidence. The state did not point to that. The state just alluded to prejudice as a whole.
Could the circuit court, taking the totality of all the circumstances, say, look, this case has been going on for a long time, lots of years. I think that when Mr. Celestine came in front of me, I observed him. I thought it was a good plea. I thought it was knowing. I thought it was voluntary. I thought it was the disposition of this case. And in the exercise of my discretion, I am not going to permit the withdrawal because I think it was a knowing and voluntary, provident plea supported sufficiently by facts. And so we're going with that. Could the court do that?
Correct, Your Honor, and that is what happened in this case. That the circuit court found that Celestine intelligently waived his right.
Without regard to prejudice, without regard to any other, just sort of say, no, this is knowing, this is voluntary. I think he knew what he was doing.
Correct. It is the defense's burden to show a fair and just reason.
So in Engelman, the court found that circuit court had abused its discretion in denying the motion in a situation where the defendant was suffering from, I think, some depression and some mental health issues at the time of his plea. Court said that's enough of a good reason that we're going to overturn the court's decision. How is this? You've got some significant mental health concerns here on the part of Mr. Celestine in terms of things going on. He's it's replete throughout. The court didn't allow him to withdraw or allow him to waive counsel because of his concerns about mental health. How is this any different than Engelman?
In Engelman, the parties in the court were not aware of his severe mental health illness. In Engelman, the court found that he was suffering from a blunted state and was not fully able to understand what was happening during the hearing. In this case, there's no allegations that Celestine was not fully understanding what was happening or competent to stand the proceedings that day. So in Engelman, his mental health was not known, and so he was not being properly treated, and in fact, he was receiving a tranquilizer, which put him in a blunted state. Here, the parties knew of his mental health. He underwent the competency evaluation, which found him competent to stand trial or to proceed in this fashion. Further, regarding the factor that this court considers regarding withdrawal is, would withdrawal waste judicial resources? In this case, allowing withdrawal based only on second thoughts undermines plea finality and strains judicial resources without any justification grounded in law. Celestine failed to show a fair and just reason for wanting to withdraw his plea.
Well, in this case, the guilty plea or the Alford plea came the day trial was set, right?
Correct.
So state had been preparing for trial. They had a pretrial hearing. Presumably they'd subpoenaed witnesses. Is that prejudice?
That is some prejudice. I would like to note that it was known on the day of trial that that is what was going to happen, is that he was going to enter into that plea, so it wasn't a surprise to the state or to the court that that was going to happen. So the jury was not called that day. So that does lessen the prejudice, but there was still prejudice, as you just mentioned.
Wouldn't the fact that you're not going to have a trial be true for every time you're trying to withdraw a plea? I mean, is that really a good reason for judicial economy?
That is one factor, especially in this case where it was pointed out that the parties had been preparing for trial versus a case where a defendant pleads right away and there was no pretrial hearings and pretrial motions practices. Those are two different situations where the prejudice would be greater when the parties were preparing for trial. If the court does not have any further questions, I will move to my closing. The record demonstrates that Celestine's plea was knowingly, voluntary, and supported by a sufficient factual basis. Celestine failed to assert a fair and just reason for withdrawal of his plea. Permitting withdrawal under these circumstances would undermine the integrity of plea agreements, prejudice the state, and waste judicial resources. Therefore, the state asks this court to affirm Celestine's conviction. Thank you.
Thank you. Mr. Mirabella, you may proceed with rebuttal.
Thank you.
I keep wondering in this case if this is significant or not. The day of the plea, Alford plea, that the court says I want to order a pre-sentence investigation. Defense counsel kind of says, you know what? Let's waive all that. He wants to waive it. I want to be sentenced today. Obviously, this case would look very different in terms of the motion to withdraw if sentencing had proceeded that day as the defendant wanted to that day. Is there any significance to that? I mean, I don't know that we have any cases that talk about it. I'm just asking your thoughts.
I think that, well, if that had happened, it probably would have significantly altered what happened here. Having a PSI, I understood why the circuit court wanted to have one for this case, to gather further information to try to make an appropriate decision, as opposed to taking a felony and rushing through it and making a decision just will go along with the recommendation and not further review it. I don't think there's any case law from my review that would give us further insight as to that, but that could have made things differently. I mean, that gives, you know, someone who decides to plea that day, that gives them more time to think about what they want to do. Now, in terms of time, and I don't think I need to spend much time on this, I think it's fairly agreed upon, it was agreed upon by the circuit court that the time here was very quick and that it favored him. I would submit that that's an important factor, but a smaller factor than some of the other more important ones. But I would also add to that factor that we had a case going on for 4 years, about 4.5, and it only took him a couple of days to go back to what he had maintained his desires were, to the extent of the significance of opposing a dismissal, which certainly doesn't make any sense if you're sitting in the defendant's chair to do that, but in terms of how many years this was going on, and then a very quick turnaround in terms of time. For prejudice here would be entirely speculative. I don't think that there's any even small indication that that would exist here. It wouldn't end the analysis. By a lack of prejudice doesn't mean you automatically should get the withdrawal. But that's really important for wondering how this might impact what the state has presented. But here we have the case being filed July of 2020, COVID and some other issues where we couldn't have trials. He eventually goes to trial 3 years later, July of 2023, exactly 3 years later. And there was no indication that the state had any difficulty producing the witnesses and the evidence. We had that trial. The conviction was not able to be reached by the jury. And then from there, the day that he ended up entering that plea was the day we were supposed to have the second trial and prepared to do so. Mr. Celestine made a choice that day to do something else. And I would note that a month before that, so October of 2024, we had a pretrial conference where everybody said we're ready to go. State said they were ready to go, even though it had been 4 years and change by that point. There were law enforcement witnesses that were readily available. There was no assertion that it would be difficult to find them or any loss of evidence or any of those
What
concerns.
about the length of, and the pendency, the length of the pendency of the case going on for 4 years as it did while there was a federal case and other things that caused the delay? Could that in some way inform the court's discretion if the court otherwise felt like, look, I've got a knowing and voluntary plea, I feel good about that, I think the plea's provident and fine. The case has gone on for a long, long time, and it needs to end. And I'm not going to, in the exercise of my discretion, grant the motion to withdraw the plea. Does the pendency, the length of the case, the idea that a case needs to at some point have a beginning, a middle, and a terminal point where it ends in the trial court subject to appellate rights, would that figure into the court's discretion at all? Or could it?
I don't recall the specific case. It was persuasive authority off the top of my head from my brief, but there was a case that I cited on this issue that the relevant time period from that court's perspective is not from date of the underlying incident to when the plea is being requested to be withdrawn. The relevant time is when you do it, coming back to the timing of how quickly you want to take that back.
Yeah, I'm not sure. I mean, like you say, I don't think those are elements. I think those are factors. I think that a fair and just reason is the standard, and I think the court can look at a lot of different things, but do you disagree with that?
No, I agree that we can look at a lot of different components here. And again, because of the interest of my time here, wrapping up, the two most important components from my perspective for Mr. Celestine is the innocence that a jury already reviewed and the mental health component that I think this is an even more problematic circumstance than what was found sufficient for State versus Engelman. And I will conclude as I see my time. May I briefly conclude?
Go ahead.
Thank you. For the primary reasons of the mental health component and the innocence component, as well as the other factors weighing for Mr. Celestine, he asked this court to reverse and remand to allow him to withdraw his plea. Thank you.
Thank you, counsel, for your arguments. We'll be in recess.
The pipes are calling from glen to glen.